Welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Patricia Kane. Patricia is a professor of law at Santa Clara University. She's been teaching law for over 37 years. Are you sure we're talking about you? Well, she briefly practiced law before she became a professor. She's a member of the Texas and Iowa bars and provides consulting services to law firms. Patricia is a frequent speaker relating to tax planning for same-sex couples and has written many law review articles on that subject. Last September, I guess it was, I went to the Kasner Symposium Santa Clara University puts on. Patricia was a speaker at that symposium, did a great job. So today, we're going to be talking about income tax problems of same-sex couples. And as we get into the subject, I want to mention that many of the problems that we're going to be talking about also relate to unmarried couples. So you may not want to bypass this just because we're talking about same-sex couples, although these days it seems like everybody knows somebody. And before we get started, I want to caution our viewers that we're discussing issues in a very complex area. This is a starting point for a bigger discussion. We want you to get qualified legal and tax advice. Also, we're mostly addressing issues from federal and California standpoints. We're going to try to maybe put in a few little nuggets here, maybe about what's going on in other states, but mostly federal and California. And in California, one of our big issues is that we have community property, and not all states do. So viewers in other states should seek advice about their local laws. Patricia, thank you for joining me today.
Thank you, Michael. You're right. 37 years is a long time. I must have started teaching when I was 10.
It must be, yes. Anyway, again, before we get started, I'm just going to call Patricia Pat, so forgive us there.
That would be fine.
Okay. So let's get started a little bit here. First of all, before we get into some of the other details about income tax problems of same-sex couples, let's focus on some developments. So what is the status of litigation for the Defense of Marriage Act? Maybe you can also talk about a little bit what the Defense of Marriage Act is about, and how does that relate to these income tax issues that we're discussing?
Sure. The Defense of Marriage Act is a statute passed by Congress back in the mid-1990s before any state had recognized same-sex relationships as marriages. It basically says, for federal purposes, for any federal statute, the word spouse and the word marriage can only include opposite-sex spouses or opposite-sex marriages. So the federal government does not recognize the legitimate marriages of same-sex couples, even though there are 6 or 7 states and a number of foreign jurisdictions that do recognize those marriages. Now, marriage is a very important issue for federal taxation. Whether you file a joint tax return or not, or file married or unmarried, is determined by whether or not you are married under state law. But for same-sex couples, it's determined by the Defense of Marriage Act, DOMA. So there have been several court challenges to this, and some of them involve taxpayers who claim the right to file jointly. There's one in the state of New York where a taxpayer is claiming the right for the estate of her deceased spouse to claim a marital deduction for the property that was given to her. The furthest along are the cases in the First Circuit. There are 2 cases, one brought by the state of Massachusetts and one brought by a public interest law firm named GLAD. And the district court in both of those cases ruled that DOMA, Defense of Marriage Act, was unconstitutional, and those cases are on appeal. Now, what's interesting is that last spring, Attorney General Holder and President Obama said they agree that DOMA is unconstitutional, and thus the Justice Department, the lawyers who are charged with defending DOMA, will not defend it in court because they believe, in all honesty, that it's unconstitutional. So now we have this strange situation where we have a bipartisan legal group called BLAG, B-L-A-G, that is mostly from the House of Representatives Republican side, that is in court defending DOMA in a number of cases. We have a case in the 9th Circuit, we have a case in the 2nd Circuit, and we have these 2 cases in the 1st Circuit. We have a bankruptcy court just this past summer. 22 judges from the Central District of California signed on to an opinion that said DOMA is unconstitutional as applied to bankruptcy. And that case was not appealed. The U.S. Trustee in bankruptcy was not interested in appealing it. So same-sex married couples are treated as though they're married for purposes of bankruptcy throughout the United States. Wow. It's only a small step to think that the same kind of argument would succeed as applied to tax law, as applied to federal tax law. In fact, a number of people have asked me recently, if DOMA is really unconstitutional, and even the Attorney General of the United States says so, can't I just file my tax return as married, filing jointly? Now, I'm not going to give legal advice about whether to do that. I do think that DOMA is unconstitutional, but that's not the only question. The IRS has been instructed to continue enforcing DOMA until the Supreme Court of the United States strikes it down or Congress repeals it. So it is being enforced, even though most of us believe that it is unconstitutional.
All right. Now, I don't know, maybe we have this later, but since you brought up the thing, can I file a joint return? I guess an approach is that we've talked about among practitioners is go ahead and file your separate returns and then file an amended return.
Oh, sure.
As a joint return.
You can do that. I mean, if you want to follow the rules, you would file separate returns because DOMA is still a statute on the books and the IRS is enforcing it, but then you'd turn around and file an amended return jointly. Now, you'd only do that if filing jointly saved you taxes. In fact, if DOMA is finally struck down on constitutional grounds, normally such rulings by courts make make it retroactive. So for any tax year that's open, let's assume the Supreme Court strikes it down in 2013. Then for any tax year that's still open, those same-sex married couples who would save money by filing jointly would amend their returns and file jointly. But there's no obligation to file jointly, so all those people who would be hurt by filing jointly will not amend their returns. I think that's a whipsaw for the government and an injury to the federal fisc, and it's something that the IRS and Congress should think about.
Yeah. Now, when you do an amended return, well, for one thing, we have what we call a protective claim.
Yes.
And so this way, you keep the statute, as I understand it, open. So in other words,
now
we got a 3-year waiting period, and then you can't go back and amend.
Right. If you wanted to protect yourself against the running of the statute of limitations, you can file. Still, you file a 1040X, which is an amended return, but you make it clear that it's a protective claim because the matter is under litigation, and you want to keep your tax year open until that litigation is finally resolved. That way, if it takes 5 years to strike DOMA down and it's struck down retroactively, you would be able to get refunds for all of the years you filed a protective claim.
Yeah, okay. Okay, well, what about, we're in California, how about Proposition 8? Maybe you can talk a little bit about that and what's going on.
That's a different sort of lawsuit. That's a challenge saying that same-sex couples have the fundamental right to marry under the United States Constitution. DOMA, remember, is just about the federal government's failure to recognize you once you are legally married in a state. So that is a case that is currently, that's the famous case that's gotten a lot of publicity because of the lawyers involved in it, and it's currently before the Ninth Circuit. There was a question about standing because the state of California didn't want to defend Proposition 8. They've taken the position it's unconstitutional, so we have an interesting parallel to the Attorney General Holder's position on DOMA. But the interveners, the people who supported Proposition 8, who brought it to the voters, they want to defend, and the Ninth Circuit is going to give them that right. So they will be the people defending Proposition 8. Everyone else will be trying to strike it down, and we'll have to wait and see what the Ninth Circuit does.
Yeah, okay. Now, another development that's happened in the last year, by the way, folks, this is, we're recording on January 24th, 2012, so that you know we do have some past shows of interviews in back years with Pat. That you can find at our website, financialinsiderweekly.com, under past episodes. Just in case we don't get into some of the stuff that we were planning on here. But another development that happened this year is that the IRS issued some guidance on their website in the form of questions and answers. And so I was wondering maybe if you'd like to comment maybe about some of the things that they addressed and those that were of particular interest.
Right. Now, we have been begging the IRS for guidance because ever since in 2010, they issued this Chief Counsel advisory that said community property rules would be respected in the state of California for registered domestic partners and for same-sex marriages. What that means under tax law is that income and deductions are split 50-50 by the two spouses who will file as single at the federal level because of DOMA. So we've had a period in our history with opposite-sex married couples who were covered by this rule, and so we have some law on this, but it was kind of a big step forward to suddenly apply this old case, Poe versus Seaborn is the name of the case, to same-sex couples in California. There are a lot of unanswered questions, and so we've been asking the IRS for guidance. Practitioners, taxpayers, politicians, everybody's trying to get the IRS to be clear about this. And rather than issue anything in the form of authority, like a revenue ruling, which would take some time, a regulation, which would probably take forever, they issued a document called Q&A for registered domestic partners. If you go to the IRS website and just put in a search for registered domestic partners, this is the document that will likely pop up first. And there are 19 questions and answers. Most of them I agree with, but not all of them, and I'm not the only one who disagrees, and I've talked to the IRS about some of these. So it's worth pointing out a couple of the Q&A. One that's very positive, and I do agree with, and have been arguing this for years, is that if you're in a registered domestic partnership or a civil union or a same-sex marriage, even though the relationship won't be recognized as a marriage by the IRS, if your partner has a child, that child becomes your stepchild because that child is your stepchild under state law, and the IRS will recognize state law. One of the questions and answers in this does indeed come to that conclusion. Now what that means, for example, is if you've got your partner's child on your employer's health plan, you don't have to prove that the child's a dependent in order to exclude the value of the benefit as imputed income to that child. As you know, all children under the age of 27 now can receive these employer-provided benefits tax-free. So having your stepchild receive that benefit is a big benefit. Oh, yeah. There are other places in the code, too, where the parent-child relationship makes a difference. One of the things I don't agree with, and this is the one that's probably gotten the most publicity, is that if one partner or spouse is self-employed, yes, and then has to file a Schedule C reporting income and deductions and a bottom line profit for the business, typically, I would report my income from self-employment on my tax return, just a single Schedule C, and then I would split the bottom line as a community property adjustment, and I would subtract on my line 21 miscellaneous income half of it, and I would report on my partner's line 21 an increase. So that we make the adjustment, but we don't make it be the self-employment income of my partner because it isn't. I'm the only one employed, I'm the only one doing the working. She may be an employee working full-time. The IRS takes the position that you're supposed to split that Schedule C income 50-50, maintain the character as self-employment income, which would make each partner liable for 50% of the self-employment tax on that. They say that because there's a special rule about self-employment tax that says in a community property state, the spouse who does the earning shall be the one who's liable for the self-employment tax. In other words, they say that reverses the rule of Poe versus Seaborn. When I read the statute about self-employment tax, the very first sentence in the statute says the tax should be assessed to the person who does the earning, not the person who owns the income, but the person who earns the income. So I don't think Poe versus Seaborn ever applies to the allocation of the burden of the self-employment tax. I think it should be for the earner. Now, I argued with the IRS at length about this. I've argued in person, I've argued over the phone, and I've sent them briefs. They are reconsidering, but I'm not holding out hope that they will change. And I was once told by someone in Chief Counsel's office that we haven't published anything that's authoritative saying you have to split it. I'm just construing the statute that way. You're construing the statute a different way. Both of us have reasonable constructions of the statute, so you could do one or the other and be safe. The only thing is, every software company that
Right.
does these programs for filling out 1040s, they're going to follow what the IRS says in its informal publications, and therefore taxpayers that follow those programs are all going to be reporting the self-employment income 50-50 on their return.